Welcome back, everybody. It is good to see that there are still some people who are keen to know about stage strata development. So hands up those who haven't been to any of the other presentations. Wow, okay. I'm just trying to work out whether I can skip any of the slides. So this presentation is about stage strata development. It's not about strata development generally. It's about staging of strata schemes. Because staging of strata schemes were one of the areas of difficulty causing problems. So we had a really good look at how we might improve staging of strata schemes to make them more flexible, but also, I suppose, more transparent for owners and others alike. So I'm Alison Fleming again. I haven't changed my persona in the last 10 minutes. I'll be speaking again for around 40 minutes with up to 20 minutes for questions. So as I've mentioned, we're looking at what the challenges are under the current Act, what's changing and what's in the proposed regulations so that you can find out more and have your say. We'll just note that there's a disclaimer. We've taken every care that we can to make these accurate for you, but there's nothing like reading the Act and the proposed regulations. And just as a matter of interest for everybody, there are actually 153 pages of regulations. They're not all the regulations. We're still working on fee regulations, for example, and we're still working on transitionals and consequential regulations that might be needed for other acts and other sets of subsidiary legislation. So there's still a lot of work to do between now and November, when we hope to, let me just skip briefly over these. Yeah, so there's still an awful lot of work to do between now and November, when we hopefully intend to gazette the regulations, table them in Parliament, and then after that proclaim the amendments to the Strata Titles Act 1985. But we're on track so far. And we're now looking in this topic at enabling more flexible staged strata subdivision. So under the reforms, there'll be more flexibility for the staged development of strata and survey strata schemes, and I should add leasehold schemes as well. There's also more transparency. We won't find the same provisions in the community titles legislation. Community titles legislation deals completely differently with staging by means of a community development statement. So these stage strata provisions are solely for the current Strata Titles Act. So what do I mean by staged strata development? Well, it's a stage strata or survey strata subdivision that's intended from the beginning to be created in stages. So sometimes a developer will choose to subdivide a strata or survey strata scheme in stages so that funds from selling the lots in an earlier stage can be used to fund the construction of later stages. Are any of you living in a staged scheme? Do any of you recall other buildings happening around you at the same time or a later time. Perhaps you weren't aware that you might have been in a stage scheme. One of the issues that we found with staging of schemes was that owners in these schemes had given away enduring powers of attorney and enduring proxies to the developers to enable the developers to basically ensure that they could make variations to the scheme and get those variations through without the owner's say. We've done something to try and protect owners in that regard. So a stage strata development is different to a scheme which is complete at the point that it's first registered. There might be one building on the land, but then there'll be a series of vacant lots, and those vacant lots are the lots that are subsequently developed, the stages. If we just have a look at a couple of plans, this shows you. So we start off with a scheme that's been developed, lots 1 to 6. And you can see lot 6 is largely undeveloped. And lot 6 has a unit entitlement of 40, and the other lots that have been developed have a unit entitlement of 12. This is just an example, but it's explaining how staging works. Okay, so the next plan, oops, we need to go that way. So the next plan shows that, oh, yes, so lot 6 has now been subdeveloped or re-subdivided. You've now got lots 8 to 12 and lot 13. So the unit entitlement has changed. And we've still got a vacant lot, lot 13. So stage 3 coming up. The completed scheme was 3 stages. Lot 13 has been re-subdivided into 14 to 17. We've now got 17 lots with a unit entitlement of 1 each. So it was a three-stage scheme. So what do I look for now when I'm buying into a stage scheme? Well, I'm looking for a management statement that's been registered when the scheme was registered. The management statement is simply bylaws for the scheme, but it contains the proposed subdivision plans for each stage and the proposed schedule of unit entitlement for the scheme if the stage is implemented. And for a strata scheme, it also contains plans and specifications of any buildings or other improvements that are shown on the proposed floor plan or location plan that are not shown on the registered plan. Then there's also a warning statement in the management statement to the effect that the proposed re-subdivision in bylaw or whatever is not binding on the Western Australian Planning Commission, local governments, or any other public or statutory authority. Now, ordinary schemes can have management statements as well. They're just bylaws, but other strata schemes obviously may be relying on Schedule 1 and Schedule 2 default bylaws. So the happy path for a stage development. Scenario 1. The plan of re-subdivision and the schedule of unit entitlement are lodged for registration, and they're the same or substantially the same as the plans that were shown in the management statement. In this case, no unanimous resolution is required from the strata company because the variations were only minor or the scheme was developed as it was meant to be developed. and there's no requirements for consents from interest holders in this case. So everybody got what they expected to get. Scenario 2. The plan of re-subdivision and the schedule of unit entitlement contain one or more variations that cannot be treated as minor variations. In this case, to register the plan of re-subdivision and schedule of unit entitlement, a unanimous resolution of the strata company is required, together with the consents of all interest holders. Now that's quite difficult to get. Unanimous resolutions are very difficult to get, and consents of all interest holders are also very difficult to get. But the way that the unanimous resolution has been dealt with previously has, as I said, been by using things like enduring powers of attorney given to the developer or enduring proxies given to the developer, so that the developer can always vote in favour of the resolution. So you might be asking, well, what are the current non-minor variations? Regulation 36 of the Strata Titles General Regulations 1996 specifies variations that cannot be considered to be minor variations. These include any change in the number of lots. So that's any change in the number of lots from the stage that was envisaged in the management statement to the stage that's actually developed. And any change in the area of any one lot if the variation exceeds 10%. Any change in the general configuration of the lots and common property. Any change in the unit entitlement of any lot. So what you're doing is you're always comparing what was in the management statement, what was I told in the management statement versus what's being lodged for registration at Landgate. Who currently decides if a variation is not minor? The Registrar of Titles does. So the Registrar of Titles determines if the plan lodged for registration is the same as the plan in the management statement, or it only contains minor variations from the plan in the management statement. There's no provision in the Act currently to dispute the determination of the Registrar of Titles. So what are the challenges under the current Act? A developer may need to make a change due to changed market conditions or changes in a local planning scheme. A variation can be non-minor and require consent of every owner and every interest holder, even though the variation may have no impact whatsoever on many owners and interest holders. The strata subdivision can come to a standstill. This has been challenging for property developers and investors, as well as leaving owners living in an unfinished strata scheme. So what's changing? Well, pretty much everything. So we're changing the terminology. So there won't be management statements anymore. There'll be stage subdivision bylaws in the scheme bylaws. The stage subdivision bylaws are governance bylaws. Then what else do we have? Okay, so in the draft regulations, a proposed stage in the stage subdivision bylaws is described as an agreed stage of subdivision. So what you'll be comparing now is the agreed stage of subdivision with what we now call significant variations. So we've gone from non-minor ones to significant ones, a much more positive spiel. Then, instead of having the registrar determining whether something's non-minor or significant, we're saying that the licensed surveyor and licensed valuer not associated with the scheme developer will determine if variations are significant. an owner of the leasehold scheme, strata company, or designated interest holder can dispute that determination. They can take that determination to the tribunal. Then designated interest holders can be deemed to have given consent to a significant variation. If I can also just draw your attention here to what we mean by subdivision, because the previous scope of stage subdivision bylaws applied only to re-subdivisions. Stage subdivision bylaws can now include the conversion of lots to common property and the consolidation of lots in a scheme. And the impact of that is that different resolutions might be required from the strata company if a variation is significant. So turning now to the significant variations and looking at and comparing our agreed stage with what's presented for registration, or what's going to be presented for registration, there are going to be the proposal is that there be 4 types of significant variation. These are set out in the draft regulations, and we're strongly encouraging you to think about whether those are the right variations. Are they the ones that should be treated as significant? So the first one is where the relative unit entitlement of an existing lot, and the relative unit entitlement of an existing lot is the proportion that the unit entitlement of the lot bears to the sum of the unit entitlement of all the lots. And we're saying that a variation of 10% or more of the relative unit entitlement of that lot compared to the agreed stage is a significant variation. The next one that we're looking at is where the total number of lots in the scheme increases or decreases, with the variation being 10% or more of the total number of lots in the agreed stage of subdivision. We've got a new one for strata schemes, and this is where the number of levels of a building on the floor plan increases from the number provided for in the agreed stage of subdivision. So the number of levels can include those above and below ground. And then the last one is a change in a registered easement or restrictive covenant over the whole or part of the parcel, unless it doesn't have a material impact on any existing lots. If you recall the previous non-minor variations, there was one relating to the configuration of the lots in common property in the scheme. We've actually not classed that as a significant variation, but we are asking the valuer, who determines if the unit entitlement change is significant, to take the configuration of the lots in common property into account in making that determination. So the first time that you can go to the State Administrative Tribunal is where you want to challenge a determination of the valuer or surveyor. The person applying to register the amendment of the scheme must serve notice of the licensed surveyor and valuer determinations on the owner of the leasehold scheme, the strata company, the owners, and designated interest holders. The application to register the amendment of the scheme mustn't be made until notices are served. At least 28 days have elapsed, and any proceedings before the tribunal on the determination have been withdrawn or resolved. The scheme dispute here is between any of the persons mentioned, that I've just mentioned, and the applicant who's seeking to amend the scheme. It's not the licensed surveyor or the valuer. So the consequences of a significant variation. The developer will need to obtain the relevant resolution from the strata company. So I say relevant resolution here because if you're dealing with what we call a Type 4 subdivision under the amended Act, that's a re-subdivision in the old language, you will need the unanimous resolution of the strata company. But if you are dealing with a Type 1B subdivision, then, which is a conversion of lots to common property, then you will only need a resolution without dissent of the strata company. The provisions relating to the consents and the resolutions that are required for registering amendments of scheme plans and schedules of unit entitlement are actually set out in section 35 of the amended Act in more detail. So the developer will need to obtain the relevant resolution, written consents, and written consents of each affected owner and consent of people with a designated interest. So this is the second time that the tribunal can become involved. Holders of designated owners must always give written consent. Holders of designated interests, however, will have 60 days to respond to a notice given to them about a significant variation and can be taken to have given consent if they do not actively respond within this time frame. So if they object to the proposed variation, they must notify the developer within 60 days and provide written reasons for their objection, and the developer can then apply to the State Administrative Tribunal to review the grounds of those objections. So if the objections are essentially unfounded, then SAT may order that the registration of the amendment of the scheme can proceed without the consent of the particular person. I've talked about designated interests. The designated interests are set out in section 3.1 of the Act. It includes a registered mortgage, a registered lease, a caveat, the interest of a judgment creditor, plantation interests registered under the Transfer of Land Act, and carbon covenants registered under the Transfer of Land Act. Notable absentee from that list, holders of easements and restrictive covenants are not required to give their consent. So just looking at scheme developers in slightly more detail, under the changes in the Act, a scheme developer is defined as either the original owner of land to be subdivided by a scheme or the owners of strata lots subdivided by a subdivision in a scheme to which stage subdivision bylaws apply. So we're not saying that every owner of a lot who subdivides their lot in a scheme becomes a scheme developer. It's only those ones who were initially involved in the registration of the scheme or are in fact the developers of the stages in the scheme. So they're required to make disclosures about certain matters to the strata company in writing, and that includes details of any remuneration or other benefits that they receive or are reasonably expected to receive, or that an associate may receive, and details of any other direct or indirect pecuniary interests that you might have. If this requirement is breached, the strata company may apply to the tribunal for an order that you pay a specified amount to the strata company, being the whole or part of the remuneration or benefit that you failed to disclose. Another obligation relates to key documents. So at the first annual general meeting, you're obliged to provide the key documents to the strata company. Key documents have been defined in Section 3 of the Act, but they've also been defined, they've been further defined in Regulation 10 of the consultation draft of the regulations. So you might want to have a look at both of those to have a look at what we mean by key documents. It includes all the documents that come into your possession or control which are relevant to the subdivision of the land. We've mentioned in this morning's session that you can be excluded from voting on any resolution for a period of up to 10 years in respect of scheme defects. We've also imposed extra disclosure obligations as the seller of a lot in the circumstances set out in Section 156.3 of the amended Act. So that scenario is where the first annual general meeting hasn't been held, the strata title scheme has not been registered, or the scheme developer continues to own at least 50% of the lots in the scheme. And you then have to provide a statement of estimated income and expenditure for 12 months when you're selling the lots. You have to provide details of the remuneration and other benefits, and you have to provide details of any contracts for service or amenities, and the details of the terms and conditions of any lease, license, right of exclusive use, and enjoyment or special privileges. Then I'd also like to draw your attention to Draft Regulation 101. It's an additional pre-contract disclosure requirement for all sellers of lots if the contract contains any restriction on voting rights. It must contain a statement that the contract restricts the buyer's voting rights as owner of the lot and sets out particulars of the restrictions. So we haven't prohibited restriction on voting rights, but we have required that they be disclosed. And a restriction on a voting right includes the buyer of a lot granting an enduring proxy to the seller, and the buyer granting a power of attorney to the seller to enable the seller to exercise the buyer's voting rights as owner. So looking more closely at the proposed regulations, go and have a close look at Part 6. That sets out the requirements in relation to what we mean by significant variations, the obligations of the licensed valuer and surveyor and the like, and also the right to challenge the determination in the tribunal. Then, as I've mentioned, have a look at the key documents, both in relation to Section 3 and Regulation 10, and then in relation to Part 14, the Protection of Buyers, Regulation 101. So we've really looked at each aspect of the staging of the scheme, looked at problems arising from the staging of the scheme, and tried to provide solutions that are fair for both the owners of the scheme and also for developers who are trying to get the schemes completed. The proposed regulations are available on strata.wa.gov.au in the document library at the bottom. If you go to the bottom of the page, you'll see document library, and that's where they are. And then for guidance on the reading of the legislation, go to the Department of Justice website for their handy guide. You can subscribe for updates on the key developments, and you can share and re-watch the overview sessions and the in-focus sessions once they've been held. Well, now they've all been held. So this is the final session. That that's not to say that there won't be any more sessions. Thank you for your attendance.